Mr. Strelitz.
My lord, my ladies, I've been encouraged by both leading counsel sat in front of me to be brief with my time, so I'll be as brief as I can be. But to answer the questions from earlier on, the application that was issued in the form N244, pursuant to, it said on its face, Rule 60, Sub-Rule 5 of the 2024 ET regulations, which...
Very odd. It says that it should have been a request, not an order. But if a request is made on the face of it, by any court, any time, the employment tribunal must comply with it.
My lord, yes, and just I've asked for those instructing me to send a couple of things on to your respective clerks. Firstly, the order from His Honour Judge Pelling, which does frame it as a request, as perhaps you might expect in light of 60 Sub-Rule 5 being drawn to His Lordship's attention. It also says that if because we had told His Honour Judge Pelling that there was a recording of it, because after the attempts at NDR had not gone anywhere, a form was filled in by Mr. Lay to request a transcript. At the time he thought that transcript was going to be a transcript of everything that happened in front of Employment Judge Cadney. When it was received on the 1st of December in the ordinary way, it was a transcript of everything but the judgment. There was then a request by email from those instructing me either to revisit that decision or to allow us to listen to the tape. That was rejected by Regional Employment Judge Pirani on the same date, as I understand it. I think that was the 2nd of December. The live application, which has ultimately resulted in this appeal, was issued at around that time, and where it was decided that the court deciding on my client's application would prefer to see a full written reasoned judgment rather than counsel's note or solicitor's note. We decided in those circumstances that there needed to be the application pursuant to Rule 65. Lady Justice Cockerill is entirely right. It was my skeleton quoted from or referred the court to paragraphs 4 and 5 of a letter from those representing the defendant, which is dated the 12th of December 2025, which put matters in neutral terms but did not dispute the High Court's jurisdiction to do it, and said in terms, having criticised the lateness, it said it's ultimately a matter for the court to determine alone in the exercise of its general case management powers, in particular under CPR 3.12p. That is a position which was then adopted by my learned friend Mr. Hankey, who appeared for the defendant at that hearing, where Mr. Hankey, it would be quite proper to say, adopted a continued neutral position, but did not dispute jurisdiction, is our point. And then His Honour Judge Pelling then acceded to that request. I have more information about the chronology if...
No, that's quite sufficient. Speaking for myself, I would like to see the order.
Oh, I'm so sorry, I said... Yes.
Inverted commas order, but apart from that, I think you've covered the ground.
So those instructions are actually, at the moment, I think, sending to your respective clerks not only the order, but also the 12th of December letter, and for completeness, Mr. Hankey's skeleton, to make it plain to the court that there was a continued neutral position adopted by them, but not disputing jurisdiction to do so.
Thank you very much, Mr. Strelitz.
Thank you.
Very helpful. Right, Mr. Tots,
yes,
back to you.
So, Lord, my ladies, I had, I think, made some submissions by reference to LA Micro. You were also taken to Malik. I don't think I need to take you back to Malik. Can I just make this point, though? That is another case where there had been a full investigation at a trial of the facts, which again is what we say needs to take place here. Now, with that in mind, can I turn from the law to such facts as, first, this court has, second, the judge had, and third, as are likely to emerge during a trial? And can I pick that up by reference to the Judge Bird's judgment? And if we can just run through that, please. On page 44 of the core bundle, paragraphs 5 and 6, the judge it dealt with the business of EDD before completion. He referred to the use of the indirect model and the use of go cardless and bottom line. He then talked about the sale and proceedings. My learned friend took you to those paragraphs. At 12 to 16, after completion, sorry, paragraph 12, after completion from about March 2021, they operated the hybrid model, and that's been described to you. I don't need to tell you about any more about that in any detail. And at paragraph 16, the judge said that the lawfulness or otherwise of the pre and post completion models is a matter for trial. I'm not invited to determine that issue, and indeed he wasn't. So at 17, the judge said this: there is an issue about the degree to which advice was shared. The evidence on the legal advice is not always easy to follow. It is presented in the evidence as a dense 8-page chronology presented in a table, and it's not complete because the defendant has asserted legal privilege in respect of some advice. It seems to me that the advice was often subject to caveats and often based on an incomplete or potentially incomplete factual background. Now, to explore that, can we go please to the table which the judge was referring to, which is in the supplemental bundle at tab 27, and we pick it up at page 259. This is a table in the witness statement of Mr. Murdoch, described by my learned friend as the key witness statement. That key witness statement was that of Mr. Phillips, which I don't think you've been taken to at all yet. I'll come back to. If we pick it up at the bottom of page 259, I'm literally going to just run through very quickly, if I may. So in June 2020, we had the confirmation before completion that FCA approval was not required for the current business, but to be confirmed whether it would be required moving forward. That's not a document that's in your bundle. We then had the SPA with various warranties. Again, that's not a document in your bundle. We then had common ground, the migration away from EDD to go and from go cards and bottom line in what was then reliance on an intragroup exemption and the use of the direct model. If we then look at around 17th September 2021, not in your bundle, EDD engaged Fox Williams to draft a formal letter of advice on whether EDD is carrying on any regulated payment services, and if so, if any exemptions apply. That was not limited to the direct model, that was in relation to the business generally. On the 29th of October 2021, again a document not in your bundle, Fox Williams issued their first draft letter of advice to EDD. They referred to the reliance on the intragroup exemption not being available, and they said that Fox Williams was carrying out regulated activity requiring payment transactions, amongst others. That then resulted in a whole lot of correspondence between Fox Williams and EDD in the form of Mr. Lay. None of that is in your bundle, and we get to the position on the 16th of November where Fox Williams expanded on their concerns about the illegality of the processing payments for non-IBC practices. That's the indirect model. Advised Mr. Lay not to migrate any more IBC clients away from go cardless or bottom line, and flagged to Mr. Lay they have initial concerns about illegality in relation to non-IBC practices. That is the letter. That letter actually isn't in your bundle, but it is referred to by the judge in his judgment at paragraph 22. It's the bottom of page 46 of the core bundle, where he says, he quotes from it, "I'm not confident that using GCL or BTL is sufficient to ensure that EDD is not performing regulated payment services." Now, my learned friend then took you to what was said to be what is said to be Mr. Lay's position, which is set out in paragraph 23 of the judgment. So informed FW, this understanding is incorrect. On the call we arranged in the email chain, FW therefore provided an updated advice later in November, which I then circulated widely. And as you saw from the passage in Mr. Lay's witness statement, to which you were taken by my learned friend, effectively, Fox Williams were provided with further information by Mr. Lay. Now, that is important because it demonstrates, I would submit, that quite what's going on is in the knowledge of Mr. Lay, and how much of that is conveyed to a legal advisor at the time in order for them to form a view on whether something was compliant or not, is of course critical to the conclusions which they are then able to draw. So if we then go over the page, please, page 261, on the 23rd of November, Mr. Lay, this is not in your bundle, Mr. Lay advised IVL that EDD had received legal advice which contradicts the guidance EDD had previously received in relation to collecting funds on behalf of IVC practices. That refers to the direct model. There's no mention of advice regarding likely illegality of the collection of funds for the non-IVC practices, so that's the indirect model. 29th of November, IVL raised concerns regarding Mr. Lay's reluctance to share information and lack of buying into being part of a larger group and all of the control compliance. That is an important letter in the light of some of the observations that have been made this morning. It's not in your bundle. But what is in your bundle is an extract from Mr. Phillips' witness statement. Can I take you to tab 28, please, page 274. Now, this is an extract, and unfortunately it's incomplete for reasons I'll explain. If you look at page 274, paragraph 33, Mr. Phillips says, it was only from around, and Mr. Phillips, sorry, I ought to explain who he is. If you go back to 269, you'll see he was the UK CEO of the Defendant Respondent, IVL, within the IVC Evidencia group. He was also a director of Vet Success. He is, sorry, a director of Vet Success, which was formerly EDD. And just so you know, it turns up in the chronology. He became CEO on the 6th of December 2021. And what he says at paragraph 33, page 274, it was only from around July 2023, after Mr. Lay had left, that myself and or anyone at IVL started to get a full and unfiltered information about how EDD operated. As I said, paragraph 8 above. Prior to this, Mr. Lay had been adamant that EDD had to operate autonomously and in isolation from IVL, and he had refused to comply with a number of requests made by IVL regarding information sharing and compliance. Now, sadly, paragraph 8 doesn't appear in the papers before you because I didn't realise we were going to have any debate about, or we didn't realise we were going to have any debate about what the judge had said about change of factual understanding, because we understand this appeal, I'll come back to this, to be solely about legal advice. If I go back to the chronology at page 261, and if we pick it up, please, on the 7th of January 2022, these are, again, further documents not in your bundle. IVL asks several questions of Mr. Lay regarding EDD's non-compliance, including various questions in circumstances where, quotes, the advice from FW is unclear, particularly regarding non-IVC practices, so that's the indirect ones. And Mr. Lay's response, and I'm sorry, the type, something like mine, the type is very small, but it's in red. And he says, where he's asked, for the purposes of PSR and EMR, is it go cardless and bottom line that perform the payment services that need to be authorised by FCA, not EDD? Mr. Lay says, that was our original position. The reason I wanted to apply for FCA authorisation was so that we could remove GC and BPS from the supply chain and reduce costs. If it hadn't been for acquisition, we would have started that application process. And then he goes on to talk about that. The point being, implicitly, he is saying, with GC and BPS at the outset, FCA authorisation wasn't required. It's only because he wants to move away from them that the need for FCA authorisation has arisen. And then you'll see, in the same date, he confirmed that he and NatWest did not understand EDD to need FCA authorisation, and that he says he was extremely surprised to receive the advice from Fox Williams. If we then go down to March 2022, this is where Mr. Chandler had some exchanges. On the 2nd of March, you'll see he asks Mr. Lay why EDD needs authorisation for non-IVC practices, given the involvement of GCL and BTL. And Mr. Lay says, too complicated to explain here, so I'll clarify tomorrow. Short version, we have to be FCA authorised to do the work we're doing. This is beyond doubt. Now, we then go back, please, to tab 3, page 17. This is the email that my learned friend showed you earlier, but you need to put it in its chronological context. The 16th of March 2022. So,
Sorry, which page, Mr.
I'm sorry, page 17. Tab 3, page 17.
Yes.
So this is the email my learned friend took you to. It's Mr. Chandler asking questions about using a PSP for IVC transactions and saying it's effectively the same as the current model for non-IVC transactions. So you get him raising a number of questions and attaching the PowerPoint slide deck, which, as you can see, calls for, it asks for explanations. My learned friend took you to that. You'll recall most of the points that is made is EDD has not adequately explained what payment services it believes it's performing in this business model, and therefore why this business model cannot continue. They want to know, they want to understand more about why, if at all, it's said to be unlawful. You haven't seen any what happened after that. On the 22nd of March, again not in your bundle, there is a board pack for a March board meeting, which Mr. Lay shares with his co-directors. He says, EDD has so far provided regulated payments without authorisation by applying the intragroup exclusions, that's direct, leveraging FCA authorised third parties for independent vet practice related payments, that's indirect. So he asserts there that it's being done without authorisation. Then 23rd of March, you'll see Mr. Phillips went for a meeting with Mr. Lay, who records that he thinks that EDD was, Mr. Lay said he thought it was now worth nothing. There is then a whole sequence of discussions which take place between May and September 2022. And in the meantime, on the 15th of July, Go Cardless gave notice of its decision to terminate the contract. On the 27th of September, Mr. Finney provides advice to Mr. Lay, effectively EDD. So in the period before EDD joined IVC, the whole of EDD's payments or business was probably unlawful. That's the indirect model. 29th of September, in an email chain between Fox Williams and EDD, Mr. Finney says EDD seems to be unlawfully providing regulated payment services to its non-IVC group customers. That's indirect. He says there are different issues. Mr. Lay says there are different issues, regulatory risks for both sets of customers, IVC and non-IVC. We are relying on the group exemption for IVC. There is no current mitigation for EDC's non-IVC customers. Again, these are both documents that were before the judge, not before you. Maloney Friend was critical of the sentence that follows, which said Mr. Lay didn't share that advice or review with IVL at the time or subsequently because he relies on a transcript. And just to remind you, it's behind tab 5 at page 31. And there's a point to be made about these transcripts, which is at the time when the statements were made for the application before Judge Bird, disclosure had not taken place. So we haven't seen these transcripts. More to the point, none of the people on the IV side knew that there were transcripts were being made. They didn't know that recordings were being made. We have now found out that there are lots of them. I don't know the exact number, but you've been in this bundle. You've got one extract from one. There are many, many more. The point that Maloney Friend relied on, just to remind you, was at page 31, where on being asked by N, that's Nishi Taylor at IVC, about how it was that the IVC are said to be unlawful, and then my friend read it to you. At the bottom of page 31, Mr. Lay said it's from a legal perspective, the possibility that the easy direct debits is deemed to be instigating those payments. Is that the right language, Chris? And Mr. Finney says, yeah, initiating payments to the process, then by go cards and bottom line. Now and then he says this, that's not a position, I must say, that's not a position that go cardless or bottom line have ever flagged as being an issue, but it is a possibility. And we've had advice that there's every chance that the regulator would look at that and say you're initiating payment. What the hell are you doing? That's a regulated activity. That's totally different to the reliance on the intragroup extension, where we think we can make a case for reliance. The context of this discussion was they were talking about applying for FCA authorization, and there were concerns about what sort of questions the FCA might ask. And this was being put forward as, well, they might ask us about the indirect model, and there is, as I hear this possibility, that it would be said that the indirect model was itself regulated and should have been regulated, and therefore they should have been authorised. So just going back then, please, to page 262 and the chronology. There are then general discussions. So that's the 30th of September, but in October, and then there are the suggestions about the commercial agency exemption for the direct model and so on. But if we then go over, please, to page 263, you'll see on the 3rd of October, I'm afraid these are documents not in your bundle, Fox Williams emailed IVL and EDD saying that any non-compliance by EDD would be due to mistakes innocently made, and suggesting IVC's lawyers did some pre-acquisition due diligence on the business before completion and didn't express any concerns either. Well, you've seen the assurances and warranties they were given. 7th of October, Fox Williams provide written advice to Mr. Lay, which is intended for sharing with IVL, which says, our working assumption is that the services provided to the non-IVC vets and customers are lawful, because every regulated payment service is provided by the FCA authorised payment institution, go cardless and bottom line. So we've gone from the 30th of September being told it's all unlawful, then watered down to it's possibly unlawful, now to it's the assumption, or the working assumption is that it's lawful. And if we could, this is a document that is in your bundle, and if we could turn back, please, in the supplementary bundle to tab 9, page 47. So you'll see this is the passage, again, point number 1 at the top of the page, it's identified by Melanie Friend, where Mr. Finney said the non-IVC vet business are working assumption, passage I've already read, working assumption and so on. But then the last sentence, we haven't been instructed to check whether this is right, but it's a reasonable assumption, and I can't recall seeing anything that might suggest it's flawed. Now, for what it's worth, I do suggest that on the part of Fox Williams was not a correct assertion, because they had been instructed to consider the regulatory position, as we saw back in 2021, and I took you to it. Yes.
Speaking about the position in October 2022 and saying we've not been instructed to consider whether it's right in 2022, you can't say that that's an untruthful statement on the basis of something that happened in 21.
Well, I can, but I'm not quite sure why not. If he was instructed to consider the regulatory position, which is what the letter, which is referred
Speaking
to.
about this moment in 2022, we haven't been instructed at this point to check whether it's right. He's not saying we have never been instructed.
Well, he's not saying at this moment. He's saying we haven't been instructed to check.
Read it in context, Mr. Topsy.
Well,
that is
I
not
am.
how it reads.
And the context is of information being partially provided in dribs and drabs when it suits Mr. Lay. And but all this highlights, with great respect, is why this should be going to trial. This is not suitable for a strikeout. So that's the 7th of October. On the 10th of October, in a board update, Mr. Lay says EDD provides its payments related services in 2 ways. First one is the direct. You can read that. The second one says where the vets are not in the same group as EDD by relying on FCA authorised payment institutions, APIs, to provide regulated payment services to EDD's customers so that EDD does not have to. So,
sorry, you jumped from the 7th of October email to something else.
I'm so sorry, my lord. Yes, I've gone back to page 263.
Right.
I'm so sorry.
Oh, it's back to the chronology.
I'm back to the chronology now. I was reading from the board update of
Yes,
the 10th of October 2022, which you don't have. But small Roman 2 deals with the indirect model. And so you can see what Mr. Lay says there. Now, on the 28th of October 22, we have the warranty claim notice letter, which I'm going to take you to in a moment. But if we can see what Mr. Murdoch says about it here, he says, stating that although IVL does not have the full picture of the current state of the company and was dependent on which information Mr. Lay chose to share with IVL, and having reserved its rights to further investigate and clarify its position, IVL claimed that EDD was conducting payment services without authorisation pre-completion. Shortly before issuing the notice, IVL explained to Mr. Lay that it had no desire to have to sue Mr. Lay or Mrs. Lay, and it was preserving its rights given the expiry of the contractual time limit. IVL then proceeded to negotiate with Mr. Lay regarding the resale back-in of EDD. It took no steps to commence litigation at that time. So it was effectively a protective letter, and I'll take you in a moment to what Mr. Phillips has to say about that. That is the letter that is referred to by Judge Bird in his judgment at paragraph 20, where he quotes the passage about not having a full picture. If we then turn over, please, to page 264. So the 10th of November 2022, there's an important typo. Mr. Lay changes his position and accepts IVL's position that the commercial agency agreement, so this was another exemption that had been decided to act upon to replace the group exemption, commercial agent exemption, works to solve compliance. And it says here for the indirect model, but it actually it can only mean the direct model. And says, as you know, the team at Fox Williams are working to ensure the commercial agent agreement is watertight so that it provides the protection we're all working towards. On the 15th of November, Fox Williams also confirmed EDD can rely on the commercial agent exemption, and you'll see the passage, the quotation that is there. Again, that's dealing with the direct model. In the meantime, Girling's responded to the warranty claim notice letter. You can see, you haven't got their response, but you can see summarised there. And if we then move forward, 31st of March 2023, EDD and IVL entered into the amended and restated agreement for the provision of services by which IVL appointed EDD as its commercial agent. 7th of June, Mr. Lay is dismissed. He commences his proceedings on the 14th of June. On the 21st of June, the email that we'll come back to, which is Mr. Finney being asked or providing a high-level overview of the regulatory advice and so on, and following which IVL files its grounds of resistance, and there is the interim hearing before the Employment Tribunal on the 30th of June. So, as you will appreciate, there's quite a lot of factual material in that period, some of which was before Judge Bird, but much of which was not, because, as I said, the statements predated disclosure and indeed service of witness statements.
What Mr. Finney says to Mr. McCarthy on that date, in terms of an overall description of how the indirect model operates, is that complete news to IVL? Is that something that, on your case, is a bolt out of the blue as to an explanation as to how it worked?
No, there have been different views being expressed through the period, and this seems to be where we got to by this period of time.
There are different views as to its legality, and I get that, I understand that. But are there different views being expressed on actually how it worked on the ground?
Well, there's no discussion of how it worked on the ground. Part of the problem, and the Phillips statement, which I'm going to take you to, I think, again, makes it clear that they don't know exactly how EDD is being operated until after Mr. Lay has been dismissed. The autonomy that he had.
It bought a business without doing sufficient due diligence to actually work out what its business model was.
Well, they bought a business based on representations and warranties. Of course, they carried out due diligence, but
Then they would have known what the business model was.
well, I don't, with respect, see how the court can possibly say that when it has no evidence to that effect. You can't just make it up. The fact of the matter is, they are not being told how the model is working, what's being done on the ground. There is evidence to that effect before the court. It's evidence that can and should be explored at a trial. The court, at a trial, may well come to the conclusion that your ladyship has come to, which is that actually they could and should have found out about this sooner. But that is a fact-sensitive inquiry.
I understand the point. Where were you going to take us to Mr. Phillips? Is it Mr. Phillips's evidence that he didn't understand how the indirect model worked?
No, Mr. Phillips, I've taken to Mr. Phillips' evidence at, let me take you to it in tab 28, sorry, page 270.
He's new, isn't he, Mr. Phillips? So
He
he's come on
comes
the
in, well,
scene late.
He's been there since December 2021.
All right.
So I'm just trying to find the.
He complains, as I recall, he complains about not being told the full story in relation to legal advice that was given to EDD.
Yeah, sorry, that's 22. It's paragraph 33, and I think I'd already taken you to it. Page 274. He says it's only from around July 2023, after Mr. Laird left, myself and or anyone at IVL started to get a full and unfiltered information about how IDD operated, as I said at paragraph 85.
That's very broad, you see, how it operated. I mean, that could mean anything.
Yes.
But I was looking for a specific piece of evidence saying I had no idea how the indirect model worked until Mr. Lay left, and I could actually peel off the layers and find out about it.
Yes. You don't have paragraph 8 before you. I had it on my screen because I had it, and Judge Bird had the benefit of it. I can't obviously tell you what it says, but I can say this, that there was plainly more information before Judge Bird than there is before this court, and in those circumstances, one cannot possibly assume that when the judge refers, as he does in his judgment, and on this I didn't understand him to be challenged, that there was incomplete, the advice was given based on an incomplete or potentially incomplete factual background, that the judge wasn't entitled to at least come to that conclusion for the purposes of an interlocutory application. So having just gone through that chronology, can I take you back to the judgment of paragraph 29, please? And this is Judge Bird, page 47, where the judge said, he's now referring to the interim relief application. In 29, the judge said this: there were 3 respondents to the ET application, EDD, IVL, and Mr. Duncan Phillips. They made common cause, so there is no distinction to be drawn between the positions adopted by each. Now, with the great respect to the judge, that's not entirely correct. The ET claim is indeed against EDD, IVL, and Mr. Phillips. and the grounds of resistance were filed on behalf of all three respondents. But the application itself seeking interim relief was made only against EDD. And you see that.
Well, it goes by its nature. If you're seeking to be restored to your employment, it's your employment with your employer.
Yeah, well, indeed, quite. Yes, oh, I'm not saying that's surprising, but I'm making the point that the judge has treated IVL as if it was a respondent to the application, and it was not. EDD was the respondent to the application.
Yes.
Because only EDD could respond to any order had one been made. Anyway, it's not an irrelevant point, because if one's being said a party is stopped, then on the basis of something that party has said in response to an application, to understand who the parties are to that application is obviously fairly fundamental, I would submit. And the parties to that application were Mr. Lay, not incidentally Mrs. Lay, and EDD, not IVL. The judgment at paragraphs 30 to 33 summarises the arguments before the ET judge, and there are some points that it's important to highlight. The respondent's skeleton in response to the application, which is referred to in paragraph 31 of the judge's judgment, is in the supplementary bundle at tab 18. And can I show you first of all paragraph 8, which is at page 141.
So is this the response to the application?
This is the skeleton argument put in response to the application for interim relief. Yes, and paragraph 8, it said, insofar as the claimant wished the first respondent to obtain FCA approval, this was not because there was any legal obligation to do so. Indeed, the claimant has not identified any such legal obligation. And that was a point that was then emphasised. If I could ask you to turn forward, please, to page 148, under the heading Identification of the Legal Obligation. And I'm sure these, again, are authorities with which my Lord Justice Byng will be more than familiar. But essentially the point being, as set out in 38, that if a breach of a legal obligation is asserted, the source of the obligation should be identified and capable of verification by reference, for example, to statute or regulation. And the point that was made is that notwithstanding the requirement to do that, Mr. Lay had not identified any relevant obligation which he said required EDD to seek FCA authorisation. If you turn forward to page 153, you'll see at paragraph 57, point is emphasised in terms of the test. Claimant has failed to establish he has any chance of satisfying a judge at a final hearing that any of the alleged protected disclosures satisfy the legal test for the following reasons. A, the claimant does not identify the relevant legal obligation he relies on. His details claim repeatedly refer in vague terms to an alleged legal obligation for regulatory approval, and then various paragraphs are identified. If we then turn to the ET claim itself, again, it doesn't identify any regulatory requirement. If we go, please, in the it must be the supplemental bundle I put before. Yes, the supplemental bundle, tab 13. You look at page 79, please. This is what was identified as being the first protected disclosure.
Is it right that all the protected disclosures referred to are disclosures to the employers or purchaser company? It's not a case of disclosures to the outside world or
No, it is right.
newspaper.
Yes, it is right. They're all communications with either IVC or EDD. So the first protected disclosure, and you see the words in italics, which is his complaint. He doesn't identify there any regulatory requirement. He says he gave an undertaking to BACS that EDD would proceed as soon as possible with the application. That, incidentally, is not an undertaking we've ever seen, but it's not said that that's a regulatory requirement of the FCA. The second protected disclosure is on page 81, and you'll have appreciated from the highlighting that nearly all of that was redacted. So there's nothing.
I don't understand this. I mean, it is some time since I practiced in the employment tribunal, but how can there be a witness statement put into the tribunal where some of it is redacted? Redacted to be kept from whom?
This document is to some extent misleading, because what the judge had, those words were not just redacted, they've been removed. They weren't seen by the judge, whereas
No.
This court can see them. The judge did not.
Which judge?
Judge Cadney, the
Yeah.
employment tribunal judge.
I should have asked Mr. Bale this, but it seems very odd.
I can't assist you with that because I wasn't involved at that time. I think there were objections were made on the basis that some of this referred to privileged communications, which had taken place without prejudice discussions. I think it may have.
Start of the skeleton, page 140.
Thank you. I'm being assisted and I'm grateful for it.
I also wasn't there. It's page 140, para 2,
I'm very grateful. Thank you.
is what I know, which is obviously just hearsay.
Yes. Yes. I'm grateful to my learned friend. Page 140, paragraph 2. The original versions of the claimant's details of claim witness statement made extensive reference to privileged communications, LPP, and without prejudice. Parties have agreed that for the purposes of this hearing, those references are redacted.
I think it was de-redacted from Philip Marshall.
Yeah. And I don't know about that either.
No, I've just read that
Yes,
somewhere.
yes, it's certainly de-redacted
Well, I see
before Judge
the
Bird.
company or companies were alleging that the claimant couldn't tell the tribunal about this because the privilege was theirs, not his. Yeah, I see that. It's still
yes.
rather odd.
Well, I confess I haven't really thought too much about that.
No
Because
matter.
for present purposes, the relevant point is that the second protected disclosure wasn't one which the judge, the employment judge, had to consider or did consider. The third protected disclosure is on page 82, going over to 82, and again you'll see no relevant regulatory obligation was identified. And the fourth protected disclosure is on page 83. That was a letter from Girlings, the solicitors. That only alleged breaches of alleged obligations under the SPA as opposed to regulatory obligations. And that position, the absence of any proper identification of the regulatory obligation, which it was said was being the models operating in breach of, was not identified. It remained the case in Mr. Lay's skeleton for the hearing. If I can take you in the supplemental bundle, tab 19 to page 161, at paragraph 14, there's what I would suggest is a rather woolly attempt to suggest that achieving BACS status as a facility management provider somehow required FCA regulation. I'd like you to read that. And the reason I say it's not, notwithstanding that the relevant the regulation itself isn't identified, is if you go back, please, behind tab 16 to page 121, you'll see in paragraph 10, this is the witness statement of Vanessa French. Paragraph 10, she says, so 3 lines down, as far as I'm aware, the second respondent has never opposed the first respondent seeking or obtaining facilities management status with BACS. I understand that facilities management status quite clearly does not require FCA authorization. This is indicated by, for example, the approved list of facility managers on the BACS website. and she gives the link. I understand that a cross-check of that approval list against the FCA register, and she gives the list for that, indicates that about 25% of the facilities managers are not FCA authorised. This is public information. So where we get to in terms of the application before the judge is, and sorry, then if you could just if I can go back to Mr. Lay's skeleton before the judge, we could turn to page 166, please, behind tab 19, where Mr. Lay sums up the public interest disclosures relied upon. He says, see, need only establish one of them. And then you see 38 through to 42, 41 really, repeats the references to those disclosures, but no regulatory requirements identified. And that remained the case before the employment judge, and you'll see he refers to that in his judgment. It's behind tab 21 at page 179. Paragraph 17, he said the claimant contends that his longer-term vision for the first respondent was that it would obtain its own regulatory authorisation from the FCA. This had not happened at the point of the SPA, and he contends there were two non-negotiable features. First, that the respondent will continue on a path to regulatory authorisation, and then he continues to run as first respondent. He contends that these terms were agreed and form part of the SPA. In pursuance of that objective, with the sponsorship of NatWest, the first respondent is able to, in principle, to acquire back the facilities management status subject to obtaining the relevant FCA approval. So he bases that on what Mr. Lay has said. And then if we go forward to paragraph 26, and again, I won't read it because it's probably quicker for you to read it yourselves, but you'll see he refers, about halfway down, he says, in respect of the regulatory breaches, they're clearly serious allegations and so on. But no regulatory requirements are identified. Now that's not unimportant, because that is the application which came before the judge to which EDD had to respond. And if we then go back to the Miss French's witness statement, which my learned friend took you to, but it's behind tab 16 at paragraph 120. Paragraph 8, she said the second respondent had bought a business which was not and was not required to be regulated by the FCA according to the SPA and disclosures. I don't think that can be challenged. The second respondent understands that there is no legal or regulatory imperative for the first respondent to become FCA regulated. It can rely on the support of regulated firms, or it can rely on exemptions from regulations. The claimant clearly knew this to be true. He'd already warranted that this was true as referred to above. And the reference to the regulated, the reliance on regulated firms is of course to the indirect model, and the exemptions from regulations is the direct model, where the exemption relied on by the time of Miss French's statement was the commercial agent exemption pursuant to the agreement which had been entered into in March 2023. Now, before Judge Bird, the appellants accepted that there was no suggestion at all that the employment tribunal was misled. And you'll see that if we go behind tab 33 at page 345, the judge is rather embarrassingly referred to as Judge Nigel. I'm not quite sure how that happened. But at the top of the internal page numbering, page 36, you'll see the judge said, and you accept, I think it's implicit, you accept, that there's no suggestion at all that the employment tribunal was misled. And Mr. Hockhauser, who was then representing Mr. Lay, said, I accept that the tribunal was not misled. what I accept is that a conscious decision was made by AVL to run an argument of complete legal compliance, having served a contrary notice of warranty, but they made a decision that that was the stance they wanted to take, and so on. So no suggestion that the tribunal was misled. And again, if one goes over the page, on page 37 of the internal page numbering, line 16, Mr. Hockhauser said, "I'm not in any way passing any aspersions on the way that counsel advanced the case." That is the case before the employment tribunal judge. What I can say is a decision was taken that they were going to run this argument. I don't have to say it was done in bad faith. Excuse me. Now, can I then go back, please, in this bundle to tab 21 to see what the employment judge had to say. And if we pick it up, please, at paragraph 12, page 178, where the judge started off by summarising the law. He does that at 12 and 13, and he identifies the high threshold test which an applicant on applications of this nature have to get past. He then set out the background taken from the particulars of claim. You'll see from the particulars of claim. You'll see that at paragraphs 14 to 18, and he makes it clear at the beginning, for the avoidance of doubt, the matter set out below is simply taken from the documents and the particulars of claim. And the reason I highlight that is because in 16, 4 lines down, there's a sentence saying, in its early years, it fell outside the scope of requiring financial conduct authority authorisation, as it was able to rely on the services of other FCA authorised businesses. And you'll see Judge Bird says a similar thing at paragraph 37. He quotes the judge saying that, but that is, as I say, based on the particulars of claim rather than any finding of the judge. He then summarised the parties' submissions at paragraphs 21 to 27, and for present purposes, my submission, we have to focus on what he identified as being the respondents' submissions, as it is an estoppel that's being alleged against the respondents. 22 is important because he identifies, he says, they submit, without submitting to detailed analysis at this stage, the protected disclosures fall into 2 categories. Firstly, breach of SPA, you needn't worry about that. Secondly, the claim alleges that the second respondent's failure to pursue the goal of securing FCA authority for the first respondent itself caused the first respondent to be in breach of the FCA and other regulatory requirements. Now that's quite an important way of putting it. It was the failure to pursue the goal of securing FCA authority which is said to have caused EDD to be in breach of the FCA. The respondents say there are factual disputes underpinning the claimant's assertions, and they're set out in paragraph 23, and the passage that my learned friends rely on is that at the very bottom of that page, having dealt first of all with the absence of any obligations in the SPA, secondly, they contend that not only did the claimant assert that the existing operating model of the first respondent that was in accordance with regulatory requirements, but that was an entirely accurate assertion. Now, I accept, of course, that has to be a reference to the indirect model. And it reflects, I submit, IVL's case, that reflected its understanding of the facts at that time, and of course it's wholly consistent with what Fox Williams had told the new CEO of EDD, Mr. McCarthy, on the 21st of June 2023, and that's the email we've already looked at. I may come back to it at page 114. At paragraph 24, the judge said that read as a whole, picking it up about 4 lines down, read as a whole, the fundamental proposition being advanced by the claimant was not that the failure to pursue the objective of securing FCA authorisation for the first respondent itself involved or would involve any breach of the FCA regulatory regime, as the existing process was compliant, but rather his underlying complaint was that the respondent's failure to do so was in breach of the SPA and or causing him financial loss or harm. This, even if true, is an entirely personal dispute which necessarily did not, and which he could not reasonably have believed to have any public interest. So the thrust of the argument there wasn't about compliance, it's about the true nature of the appellant's complaint. And then we get on to 25. The other fundamental point made by the respondent is that it has provided evidence and so on, both in the form of witness statements and in the documentary evidence contained in the bundle, which sets out clearly why the claimant was dismissed and the basis for concluding that he had been guilty of gross misconduct. And then he goes on to deal with that in a little more detail. If we then turn to the judge's conclusions at 28 and 29, page 102, 28, he says, well, there are live issues of fact. Well, he says, well, first of all, he says, I fundamentally accept the respondent's submissions. It's not impossible that the claimant will be held to have made one or more protected disclosures, but on the information before me, there are live issues of fact and law, which mean that it's not possible to say it's likely in the sense set out above that he will do so. Now, just pausing there, he didn't therefore accept what was being said by EDD about compliance. He just said there are live issues of fact and law, and that the hurdle which Mr. Lay had to get over, he couldn't get over. But then, and critically, at paragraph 29, he says, secondly, whilst I accept the claimant's criticism of the procedural flaws and so on, it does not follow in my judgment that the tribunal, which ultimately hears the claim, will reject the proposition that the reason given for the dismissal was the genuine reason. Points made by the claimant may be good ones, he may ultimately succeed, they're not sufficient to cross the high threshold for making a continuation of contract order, and accordingly the application is dismissed. So the dismissal of the application is linked, well, it's probably both, but he actually says it at the end of the second conclusion in paragraph 29. In our submission, that is a standalone reason. It had nothing to do with anything that was said about the regulatory status of EDD. And whilst I, of course, take on board my Lady Justice Andrews' point about momentum and so on, there's no, it can't be said, I would respectfully suggest, that there was any momentum required on a regulatory point to get home this second and fundamental ground which the judge accepted. Now, if we go back to the judgment of His Honour Judge Bird at bundle, core bundle, page 48, pick it up at paragraphs 64 and 68. So, paragraph 64, page 52, the judge said the ET decision was concerned with the apparent protected disclosures and the question of whether EDD was unlawfully carrying on regulated activity. At the time, both the indirect and direct models were in use. The ET found, in effect, that the direct model, which required authorisation, could be dropped. Now, pausing there, with greatest respect to Judge Bird, I just can't see where that comes from. There's no suggestion in any of the submissions or indeed in Judge Catherine's judgment that the direct model could be dropped and that the indirect model was not a regulated activity. And he then says, without any further analysis, I accept that the position adopted by EDD and IVL before the ET was a material factor in that decision. And again, at 68, he says, I accept that the stance before the ET was a material factor in Mr. Lay not being awarded the interim relief he sought, and so not being reinstated. Well, with great respect to Judge, it's very difficult to see, in the absence, complete absence of any analysis by him of the judgment of Judge Cadney, why he accepted that, or the basis for doing so. And your Lordship and Ladyships will appreciate the reason I'm emphasising this point is because I may not have to rely on it, of course, but it's one of the grounds key ground, I would suggest, of my respondent's notice if we
Yes.
if we get to that. Now, if we stay with the judgment of Judge Bird, paragraphs 65 to 68, it's also important to note that at 65, the judge says, why does the defendant take the first stance? On the evidence I have considered for this application, which I would have submitted was rather greater than the evidence before this court, the defendant advanced that position to the ET because that was the legal advice that it had at the time, based on the factual background as it was then aware of. And I submit there was sufficient material before the judge for the judge to come to that conclusion.
Did you come to that conclusion if you didn't know what legal advice your clients had received? There was no evidence before him of any legal advice that your clients had received.
Well, there is the evidence. There's plenty of evidence of it. Actually, I took you through it in the statement of Mr. Murdoch, because many of those Mr. Lay was communicating not just with himself at EDD, but
There's evidence as to advice that was given to EDD which was transmitted to your clients, and there's the evidence of what Vincent Mason said, which is in the slides. But there's no evidence of any direct legal advice taken by IVL as far as I can tell at all.
But for the purposes, well, no, but for the purposes, well, I say, well, no, for the purposes of the ET application, Mr. McCarthy, who was the new CEO who'd replaced Mr. Lay, specifically sought advice from and was given advice by Mr. Finney, which is in the 21st of June email. And it's EDD that was responding to that application, and in responding to that application, they clearly relied on what Mr. Finney had told them. Indeed, it's quite difficult, if I may respectfully say so, for the court on the one hand to say, well, IVL, what advice can IVL point to that it relied on, when at the same time seeking, the claimant, the appellants are seeking to stop IVL for something that was relied on by EDD in response to the application.
Okay, so the point is that the respondent to the application was EDD and the advice was given to EDD, and that is what the judge is sort of eliding by referring to the defendant.
Yes, but if we're going to take that stance, then we also have to, with respect, take the stance that IVL is not a party to that application. Therefore, nothing was said by IVL to the judge, because the response to the application was a response of EDD. Otherwise, there's a piece of cake and eat it going on
No,
here.
I just wanted to understand. So you say that we should read the defendant as meaning EDD.
Well, what I've done, I hope, is pointed out that the application was made only against EDD,
Yes.
as plainly it had to be. And
The tribunal.
yes, of course, yes, I'm sorry.
Obviously, the
No,
defendant before Judge Bird is IVL.
indeed. But for the purpose, but in that the point that is relied on as against IVL is a stance taken before the employment tribunal by EDD, then either one says, well, that's EDD, it's a completely different party, so what, it's irrelevant. Or if one is going to say, well, no, that is relevant because EDD was a wholly owned subsidiary of IVL, but in which case IVL must be entitled to rely on the advice that EDD was receiving to explain the stance that was taken before the employment charge. But at all events, this is the way in which, the way in which the application was put before Judge Bird was that IVL was stopped because of what was said by EDD in response to that application. That was responded to by IVL saying, well, that response reflected what it had understood at the time and the factual information, both facts and law at the time, facts and legal advice at the time. And that was what Judge Bird was considering. But the important point I make and I'm sorry, I know I'm repeating myself, but if there are difficulties with this, surely that means we should just have a trial. We don't have any fears about having a trial, because then the whole matter can be explored fully, and there can be a proper investigation of points which, to be blunt, were not being canvassed before Judge Bird, but have been, in a sense, raised before this court, and we can explore them.
Waive privilege.
So, yes, I was at 65, 68. Yes. So can I then, having been through the judgment of Judge Bird and Judge Cadney, can I now turn to the grounds of appeal? And it's perhaps worth reminding ourselves what those grounds of appeal are. They're in your core bundle behind tab 1 at page 14. So the first ground of appeal is that the court failed to take into account that the legal advice given by DLA had been withheld on grounds of privilege, and that's developed. Ground 2 is that the court failed properly to consider the advice of Mr. Finney on the 21st of June. 3 is that the court took account of an immaterial fact by considering facts or legal advice received after it had pleaded the contradiction. And ground 4 is changing legal advice should not be a determining factor in the broad merits-based assessment. So those are, I would respectfully suggest, quite narrow grounds of appeal, and in particular they focus on the role of legal advice in the judge's analysis. They don't engage or indeed address the judge having also found that IVL's awareness of the factual background was itself relevant and had changed. They seek to place a necessarily nuanced analysis of an allegation of estoppel by conduct within, we would submit, an artificial straitjacket. They fail to engage with all of the evidence before the judge on which he based his decision, and they ignore the limitations of seeking to resolve this issue by way of an interim application. And in particular, as regards that, IVL had served detailed witness statements setting out why it had taken the approach it did in June 2023, and to our submission, that is not evidence that one can simply reject on a summary basis. These are familiar principles, I'm sure. But the effect of the judge's rejection of the strikeout application is that the appellant's defence to the counterclaim of estoppel by conduct, or approbation and reprobation, as they call it in their pleadings, falls to be determined at trial, which we say is the correct outcome. If I can then turn, having made those general points, to the specific grounds. Ground 1, and they developed this in their skeleton argument, paragraphs 32 to 37. I don't think I need to take you to it because I'm conscious of that you will have already read it. But can I make 9 points in response? First, excuse me, sorry, the judgment at paragraph 17, the judge recognised and accordingly took into account that the evidence in respect of the legal advice was not always easy to follow and was not complete. When the application was made, disclosure in the main action had not been completed, witness statements still to be served, and in fact, as we've seen, the judge had significantly more material before him than this court has, as I've partially demonstrated when we went through the chronology. At the trial, there is going to be considerably more contemporaneous documentary evidence, as well as oral evidence from a number of witnesses, in addition to those who made statements for purposes of the strikeout application. So that's the first point. The second point, the judge recognised that the advice was often subject to caveats and often based on an incomplete or potentially incomplete factual background. In order to carry out the broad merits-based assessment identified by Sir Christopher Floyd, the starting point has to be a full understanding of the facts. What did IVL know at different times? What was it told? What underlying materials were provided to it and when? What was withheld? The judge had, as I mentioned, the statement of Mr. Phillips, for which you've seen some extracts, as well as the evidence from Mr. Murdoch. And just one point on Mr. Murdoch's statement that I don't think you have seen. Yes, if we go please behind tab 28 to page 270.
Tab 28 is Mr. Phillips.
I am very grateful, and that is indeed who I wanted to go to. I'm grateful to believe. And I think I've already shown you this, haven't I? I've shown you this, 23 and 33. Yeah, sorry, I'm guilty of showing you the same material. My third point, this is an interim application. It's made very late in the day, after 2 CMCs and directions have been given for disclosure, witness statements and expert evidence. That application, though, was for a strikeout or summary judgment, which, if it had had any merit, could and should have been made following service of the required defence to counterclaim on the 19th of March.
So what, Mr. Thompson?
Well, so, my lord, it goes to the question of a broad merits-based assessment. There was obviously an assessment in the claimants' camp that this wasn't suitable for strikeout or summary judgment back in March 2024. In December 2025, they have an epiphany, and for some reason, unexplained reason, they suddenly decide, oh, well, now we can do this. There was nothing that had happened in the interim that I'm aware of which justified that change of position. And as this court and other courts have frequently said, if you're going to make applications for summary judgment and for strikeout, they really ought to be made promptly when the pleadings are closed, not left shortly before the trial. We have a trial date in November. We have witness statements on the block ready to be served. In fact, the date for service of the witness statements had already fallen due and was put back at the claimant's request, but ours are ready to go. So,
what is the actual trial date?
I'm going to have to ask someone to help me with that.
9th
9th of November.
Of this year.
I'm told it's the 9th of November.
And what length of trial?
8-day trial. Yeah.
Thank you.
So we have all of that. The hearing before Judge Bird was not a trial on the merits from which the broad-based assessment could be made. He didn't have to reach a final conclusion as to whether there'd been a change in legal advice. To the extent that it said his judgment seems to do that, well, then I don't seek to uphold that. I simply seek to uphold the outcome, which is the dismissal of the application. It was sufficient for him to conclude, on the basis of the material form at an interim stage, that he couldn't properly conclude at that stage that the position of IVL, or the conduct of IVL, was abusive, as we accepted. And that was the position we said should be adopted below. The fourth point is the appellants identify in paragraph 36 of their skeleton argument the case of Wentworth and Lloyd as authority for the proposition that no presumptions are to be made against a party that declines to waive privilege in a document. It's quite an old proposition with which no doubt the court's familiar. And yet, in many respects, that is what this appeal seeks to achieve. The argument seems to be that because IVL has not voluntarily disclosed the advice that it obtained from DLA Piper, it should be somehow presumed that this advice did not support its explanation of its approach. There is no basis for such a presumption. Because it would fly in the face of Wentworth and Lloyd. Fifth, although the appellants complained about the absence of the DLA advice in general terms at the hearing before Judge Bird, it was not a point that featured in their skeleton argument. Indeed, when they were pressed by the judge as to its relevance, the appellants submitted to the judge that IVL could have waived privilege, and that unless it did so, the court did not have the whole picture. You can see that in the transcript. It's behind tab 33, page 349. At internal page numbering, sorry. Yes, it's 142, page 350, I'm so sorry, page 350, internal numbering, page 142, where at the top the judge says, I mean, the rhetorical answer may be the trial judge would have all the evidence. And Mr. Hockhauser said, but what evidence does he need to have that you haven't got? And the judge said, well, the evidence, I suppose, that would fill the gap you pointed out. Mr. Hockhauser then made submission, well, would it? Because they're still claiming privilege. There's no way we can compel them. They've refused to do it, and so on. So that was the way in which matters are now put before your lordship and your ladyship is far greater, and more, the point is made as if it's far more significant than it ever was before the judge below. The sixth point is that the appellants have never actually applied for disclosure. I'm not inviting them to, but they've never applied for disclosure of any legal advice received by IVL on the basis of an implied or a collateral waiver of privilege. They have invited IVL to waive privilege, but they don't claim to be entitled to it. And on that basis, the judge was entitled to consider, for interlocutory purposes, the application on the basis of the evidence before him, and particularly where he has evidence from Mr. Phillips and Mr. Murdoch as to their limited understanding of the facts.
Isn't the simple point that's being made against you, rightly or wrongly, that if a party is going to say we justify our change of stance on the basis of our legal advice, and the court only knows a snapshot of what that legal advice was, how can it possibly evaluate that that is a justification for the change of stance? And basically what the other side is saying is you've got to put up or shut up. You can choose, of course, to play your cards close to your chest, but if you want to justify the change of stance, then you have to put up by showing what that legal advice was in order to demonstrate that there was a change in it. And it's not good enough to just put part of the picture before the court. That's the argument, rightly or wrongly, that you have to face.
Yes, not an argument, incidentally, that was put in those terms before the judge, but I think it's actually quite interesting because it touches on the authority that was added to the authorities that my learned friend introduced for this bill, which were not before the judge. And in particular, the decision of Edwards Tubb against J.D. Weatherspoon, which you haven't been taken to. Yeah. But it might be worth just taking you to that now. It's not a case on which I rely, but it perhaps picks up to some extent my lady's point. It's behind tab 17 in the updated authorities bundle. It's a personal injury claim. And can I take the facts from the headline? After the claimant was injured at work, the solicitors followed the procedure under the pre-action protocol for personal injury claims and the CPR by giving notice in the letter before action to the defendant of the names of 3 orthopaedic surgeons they might instruct, so that any objection might be made. With no objection having been taken, the claimant instructed one of the nominated experts who examined the claimant made a report. The defendant admitted liability, only the extent of the injury and quantum remained an issue. A few months later, the claimant instituted proceedings, particulars claims supported by a medical report of a different and unnominated orthopaedic surgeon. That report mentioned that the claimant had seen an orthopaedic surgeon previously. The defendant, while recognising that the earlier pre-action report was a privileged document, applied for its disclosure on the ground that such disclosure should be a condition of the permission the claimant required. The Deputy District Judge granted the application, so that reliance on the later report was conditional on disclosure of the unused earlier report. Judge allowed an appeal, discharging the condition on appeal by the defendant held allowing the appeal, while the pre-action expert report obtained by the claimant for the purpose of advice about the conduct of litigation was a privileged document which he was entitled to keep to himself, the prime duty of such an expert was unequivocally to the court, and once a party had embarked on the pre-action protocol procedure of cooperation in the selection of experts, there was no justification for not disclosing the report of an expert who had been put forward by that party as suitable, had been accepted as such, and it was appropriate for the court to exercise the control afforded by CPR 35.4. So very, very different facts to those with which we are concerned, in particular because it relates to a personal injury case and so on. But if we go forward, please, to page 331, this is the passage that I understand learned friends to rely on. It's a paragraph 10 in the judgment of Lord Justice Hughes, who says, having referred to the privileged nature of the report, he says this: that is not to say that circumstances may not sometimes lead to the practical necessity to waive privilege. A litigant who sues former advisors will normally have to waive privilege in order to get his case off the ground. The same may be true of, for example, an appellant who contends that his criminal conviction was the result of incompetent advocacy in the court of trial. A litigant who wishes to establish the chronology or content of advice received will often have to waive privilege to do so. So may a litigant who wishes to demonstrate that, contrary to appearances, his account of events is not new. It's not uncommon for litigants to be confronted by such choices between waiver and the abandonment of a line of attack or argument. The question of principle, which this case raises, is whether the power to impose a condition on the grant of permission to rely on expert B can properly be employed to require the disclosure of the privilege report of expert A, and if so, when. And then he goes on to consider the particular considerations that arise in personal litigation. So I think paragraph 10 is, in a sense, picking up the point that your ladyship may have had in mind. The point I would make is this: it's not been suggested in our case that IVL has not been put to an election to waive its privilege in respect of any advice that it's received, failing which the counterclaim will be dismissed. Now, that wasn't a proposition that was put before His Honour Judge Bird. It's not a proposition that's ever been put to us or has been sanctioned by the court, and it's not a basis on which, on an appeal to this court, it would be proper now to say, oh, you haven't waived it, so bad luck, we're going to strike out your counterclaim. I'm not inviting this, but there is no reason why, if the claimants feel that there is a grounds for saying that we have to make an election, for them to make such an application. But were it to be made, it would need actually quite careful consideration, and I would certainly want, my clients would certainly want reasonable time to consider the terms of any such election, because first of all, we'd need to think about what the basis for the application was. We'd need to think what is the extent of any waiver that can properly be claimed. There may be grounds for saying there should be a reciprocal election, but my point is this isn't something that we can or should be trying to grapple with now. And so, my lady, whilst I hope I've answered your point by taking you to some authority, what it doesn't do is, I would respectfully suggest, enable this court to say, oh, well, you haven't elected, bad luck on your ear, which is roughly what I think where one ends up with if we're not careful. My lady, forgive me, I went off track a bit there.
Sorry, that was my fault for asking.
No, it's always helpful. Yes.
Are we done with Edward's Tub?
That was Edward's Tub, yes. My seventh point is, and I have to say I was amused when my learned friend referred to the well-known adage, what's sauce for the goose is sauce for the gander. Can I take you, please, in the supplementary bundle to tab 23. This is the first witness statement of Mr. Lay, dated the 14th of February 2025, and served in response to applications for strikeout and summary judgment made by my clients on the counterclaim, which were unsuccessful. They were heard by Mr. Philip Marshall
About to
sitting.
show us that Mr. Lay said you can't possibly deal with any of this at this stage because it's all for trial.
Your
I take it.
ladyship is, as ever, ahead of me.
Yes.
Page 186. Perhaps the clue was source of the goose, source of the cow.
It was rather.
Yes.
Paragraph 98.
Yes.
The defendant seeks to strike out references in the RDC which identify the defendant's case in the Employment Tribunal regarding my alleged unfair dismissal in the High Court are conflicting and contradictory. I maintain that they are, and that the determination of the issue of approbation and reprobation should be a matter to be determined at trial. Mr. Lay and I couldn't agree more. And then if we turn forward, please, page 189, paragraph 111. He talks about the compliance case, but at the end of that paragraph he says, I do not understand how it can be an abuse of the process of the court for that point to be made in reply and defence to counterclaim. That's his position. The claimants should be at liberty to make a case based on that, and at the very least to put it to the defendant's witnesses in cross-examination. So it is slightly ironic in a case where people are talking about parties blowing hot and cold, and I'm the one that's.
Was it just so I get a grip on this? Was it at that stage IVL's case that the complaint of approbation, reprobation by your clients that Mr. Lay couldn't make that complaint, and that in itself was an abusive process?
I wasn't. I'm afraid I
I know
wasn't
you will,
involved.
but I just don't quite understand what he's saying at 111 at the moment.
I think there would need to be a bit of historic trawling.
Yeah, all right. Well, don't worry. But I mean, it just looks to me in context as if what Mr. Lay is responding to is a complaint that in his reply and defence to counterclaim, he's raised this point, and it's said that somehow that is abusive.
Yes.
And he's saying, well, I should be free to make a case based on that. And you say, well, yes, but he's earlier said, well, if he does make a case based on that, it should all go to trial.
Right.
Yes.
Yes. There was certainly a strikeout application before, Mr. Marshall. I think there may have been a summary judgment application of some sort as well. And I think this part of Mr. Lay's statement may have been responding to that. I think it's also right to tell the court that that part of IVL's application was not pursued, so there was no decision by Mr. Marshall based on or relying on that particular part of Mr. Lay's witness statement. But it doesn't detract from the fact that, of course, he said it, and it's completely contrary to the position he's now adopting. That was my 7th point. In my 8th point is this, sorry. In their skeleton argument before Judge Bird at paragraph 60, and this is behind tab 24 at page 215. They sought to, and Mr. Lay sought to anticipate the point that was made, or point that is made by IVL, which is, well, this is the pot calling the kettle black, because you yourself are running a contradictory case, because you said at the time when you were claiming that there had been protected disclosures, that you had pointed out that EDD was operating unlawfully, and now there's a breach of warranty claim. You're saying, oh, no, it was acting lawfully. So it was, in a sense, to try and anticipate that point. And what is said, if I can pick it up in the middle of the paragraph, the sentence beginning, he is now defending.
Which paragraph?
It's paragraph 60. I'm sorry, my lord. And it's 6 lines down, 6 or 7 lines down. The paragraph sentence beginning, he is now defending. So this is of Mr. Lay. He is now defending a highly technical counterclaim about the PSRs, which is a function of the legal advice received and his understanding of the relevant facts and law. And with respect, again, we agree with him. That is exactly the position EDD was in when the appellant made, when Mr. Lay made his interim application to the ET. The complicated or highly technical understanding of the relevant facts and law is exactly what we need to be looking at. And it is important in our submission to have in mind that Mr. Lay is the protagonist in both the Employment Tribunal and this commercial court claim. And if IVL's pleadings are inconsistent, that is in part because it has faced inconsistent claims from Mr. Lay. As I explained a moment ago, before the employment judge, he claims to have made a protected disclosure regarding regulatory position. If he was right in saying that the indirect model was unlawful, then he was in breach of warranty, but that is something he denies in these commercial court proceedings. And it's perhaps also to some extent why the focus in the employment tribunal is very much on the direct model rather than the indirect model, which comes again to whether there's a clear contradiction. But it's also IVL's case that there was what I'm going to call information asymmetry between the parties, because Mr. Lay was running EDD. He knew what was going on in a way that IVL did not, and there is a factual issue as to how much he shared with IVL. And we do say, it would be surprising to say the least, that although IVL was at an informational disadvantage if it was treated as having a full understanding of the facts and the law as at the 30th of June 2023, so that its counterclaim should be struck out, while Mr. Lay is permitted to proceed with an employment tribunal claim, because it's only been stayed, it hasn't been dismissed, or determined, with an employment tribunal claim which alleges that there were regulatory breaches and that he was making protected disclosures in respect of those breaches, but denying any breach of warranty in this case. Well, that was my 8th point. My final point is on ground 1 is Gerber, the decision which my learned friend referred you to this morning, and whether reliance on Gerber is of any assistance to the court. In my submission, it's not. That will be a case that is, I think, probably familiar, or the passage that was read was probably familiar to the court, but it was a case concerning the application for an extension of time for claiming judicial review in a planning context. So again, facts far removed from our case. The passage relied on at paragraph 53, we say, is of no assistance because ours is not a case where IVL is relying solely on change of solicitors, change of advice, therefore I should be allowed, please, an extension of time. Those are not the facts of our case. It's an evolving understanding of the facts that has caused IVL's position to evolve itself and change. Ground 2 is of the appeal is in the core bundle at page 15. It's developed in the skeleton at 38 to 41. It concerns the Finney email. That is the email in your supplementary bundle behind tab 15 at page 113. It followed a request from Mr. McCarthy to Mr. Finney of Fox Williams, who'd been advising UDD and Mr. Lay for some time. The gravamen of the complaint, sorry, forgive me. If we look at the skeleton, my learned friend's skeleton, it's behind tab 2, page 31.
Not looked at as the whole, is the complaint.
Sorry, my lady, I didn't.
Yeah, the complaint is, didn't look at the whole of the email, only looked at part of it.
Yes, but I'm not quite sure how that fits in with the way in which the position has been presented this morning. But be that as it may, let us look at the Finney email. because it starts on page, the bit that we're concerned with, starts on page, behind tab 15, on page 114, where under a summary of the regulated payment services issues advice, small Roman 2, you see the passage to which you've been referred several times now. So that the direct debit collection and remittance services are probably provided lawfully. At yes, at small Roman 5, if we go over the page, Mr. Finney also advised about the direct model. He said EDD has been trying to regularise its position on the IBC vet side of its business for most of the last 18 months. And at small Roman 7, which is on page 116, he referred to the commercial agents exemption and the steps that have been taken in relation to that, in particular the entry into the amended and restated services agreement, and I ought to read those themselves. And that essentially corresponds with the position taken by EDD before the Employment Tribunal, as set out in the evidence of Vanessa French, which we have seen, that it understood there's no legal or regulatory imperative for EDD to become FCA regulated. It can rely on support of regulated firms, or it can rely on exemptions from regulations. What's said in the appellant's skeleton, sorry if I can go back there and pick up the passage I wanted to refer you to. It's a paragraph 41. It said, 4 lines in the bottom of paragraph 41, IVL took a cynical and tactical decision to assert the unqualified lawfulness of EDD's entire business so as to defeat the interim relief application and prevent Mr. Lay from returning to his role. As that position since lost its convenience, IVL has sought to resile from it. Well, that is completely the opposite of what was said to Judge Bird, and I took you to the passages earlier where it said in terms that we were not intentionally misleading the Employment Tribunal judge. So the suggestion that IVL, or EDD in fact, took a cynical and tactical decision before the Employment Tribunal judge is completely contrary to the argument that was advanced before Judge Bird, and therefore should not be given any credence before this court. Now, it's in this context that the appellants rely or refer to the importance of the warranty notice, and I did say I'd come back to this. The warranty notice is in the supplementary bundle behind tab 11 at page 59. That's if I can just take you to it. And as Lady Justice Cockerill rightly pointed out, it relates only to the indirect model. And the gravamen of the complaint is quite limited. It's on page 60, where it identifies Regulation 138 of providing payment services and says, at all material times, prior to completion in breach of Regulation 138 and other related UK financial services law, the company provided payment services in the course of its business. And you'll see, although it asserts that, it provides almost no flesh on the bones, if I can put it that way. And the reason for that becomes very clear when one is reminded of what is said on page 59 under post-completion developments. And it's worth reading both of those paragraphs. So Mr. Lay's remained as statutory director and so on. Both in terms of the employment contract and the SPA, extensive reserved matters were conferred upon Mr. Lay for a period of time post-completion, The reserved matters provide Mr. Lay with very significant levels of control and authority in relation to the company. Mr. Lay has continued to run the company on a day-to-day basis, direct and decide upon strategy, instruct solicitors and direct employees with relatively minimal engagement with or deference to IVC or the other directors of the company. For these reasons, IVC does not have a full picture of the current state of the company. IVC is very largely dependent on the information which Mr. Lay chooses to share with it. Accordingly, the full details of the warranty claims are still being investigated by IVC. IVC expressly reserves the right to supplement, amend and vary the warranty claims in light of full disclosure from the company and as investigations progress. And as we have seen, Mr. Phillips says, well, we didn't actually get that information until after July 2023 and the hearing after Mr. Lay had been dismissed and the hearing before the employment tribunal. Now, it's also relevant just to go back and pick up the point that was made by my own friend about the contrasting the warranty notice and the, what I would say, very limited and thin allegation of breach that they were able to make at that time with the email from Mr. Finney of the 7th of October. And you'll see that behind tab 9. I think my learned friend took you to it earlier. This is page 46 of the supplementary bundle, where he says on page 47, this is the working assumption point, where he says he hadn't been instructed to check whether this is right. So that's the 7th of October. And one can compare that with the position on the 21st of June, which is behind tab 15, page 114, where what is said in small Roman 2, the bottom half of that page, is no longer said to be an unchecked working assumption. That is unqualified in terms of the advice that is, I use the word probably, but beyond that, it's unqualified. Coming back to the warranty notice, can we make 3 points? Firstly, as noted by the judge at paragraph 20, it was a notice that was served on the day that it was, because that was the very last date on which such a notice could be served in order to maintain IVL's ability to make a claim for breach of warranty. So it was a date that was forced upon it. Secondly, the language of the warranty notice itself, and I've taken you to that. Thirdly, Mr. Phillips had provided evidence as to why that notice was served. If we can go please to paragraph 42.6 of his statement, it's in the supplementary bundle at page 277. At 42.6, Mr. Phillips says, in October 2022, IVL began to suspect that Mr. Lay and Fox Williams were withholding the full picture on EDD's compliance situation. We issued the warranty notification letter based on these suspicions to preserve our position, but expressly saying that only Mr. Lay knew the full and true position and we did not. And you'll remember Mr. Murdoch's evidence about that. I took it a bit earlier, but just to remind you, page 263, where Mr. Murdoch explains, the bottom page 263, that shortly before issuing the notice, IVL explained it had no desire to sue them and it was preserving its rights, given the expiry of the contractual time limit and so on. And that they were in negotiation. Once again, though, it's a point in my submission if there's any substance in it that can be explored at trial. And it doesn't justify any criticism that the judge either failed to consider the Finney email or the warranty notice. Ground 3 is at page 15 of your core bundle. It's alleged that the court impermissibly took account of an immaterial factor by considering facts or legal advice received after it had pleaded the contradiction in the present proceedings. Although that's developed in their skeleton argument, I didn't hear my learned friend address that point. It's based on two erroneous assumptions. First of all, it said there's no evidence before the judge of any development in IVL's understanding of the position between the Employment Tribunal hearing and the filing of its counterclaim, but that's incorrect. There was evidence from Mr. Phillips on this point. You'll see that in his witness statement at paragraph, can I just give you the references as the point wasn't developed by my learned friend, at paragraph 35 and paragraphs 42.12 and 42.13. Effectively, that evidence was that following Mr. Lay's dismissal, it took several months to understand what had been done and why, and the full extent of the non-compliance. In July, IVL started a fact-finding exercise. In October 2023, after the fact-finding exercise and having taken further legal advice, IVL concluded that EDE was actually non-compliant for the full duration of Mr. Lay's leadership. At paragraph 42 of the judgment, the judge also quoted the evidence of Mr. Murdoch. This is not in the bundle, but it's quoted by the judge, paragraph 42, where he essentially says the same thing and explains that they reached that conclusion in late September, early October 2023. That's the first, so it's based on that first erroneous assumption. The second is that somehow a broad merits-based assessment for a purpose of estoppel can't take into account later developments. In our submission, there's no requirement in the authorities. The court should limit its analysis in that way, and there's no principal basis for any such limitation. So on those circumstances, we say ground 3 doesn't get airborne. Ground 4, which was developed by the appellants in their skeleton at paragraphs 49 to 55, it's at page 16 of the core bundle. This is the contention that as a matter of law, a change in legal advice could never provide justification for a party to change its case except in the clearest circumstances. That, we would submit, is a fairly radical proposition for which no authority has been identified and which in fact would represent quite a significant departure from the settled law. And indeed, it's inapposite for determination on a strikeout application. But fundamentally, it's not a change to the law that is required or appropriate. It doesn't assist the clarity of the principle or the interests of justice. A broad merits-based assessment, not constrained by strict rules, is one that enables the court to take into account the circumstances of any change in position as a result of legal advice. It gives the court a much wider and more flexible approach to the principle of estoppel, which is, one would have thought, exactly what that particular principle requires in these circumstances. And what's suggested in ground 4 would result, we submit, in a limitation of the principle as identified by Sir Christopher Floyd in LA Micro. But if one was to be tempted to go along that road, it would still cause all sorts of problems. And starting with, what are the circumstances that the court would define as being the clearest? What are the clearest possible circumstances? There are, of course, a number of different reasons why a party may receive different legal advice over time. It could be as a result of new facts coming to light. It could follow new authority or new regulatory guidance. It could be the result of instruction of a specialist in the field. And depending on the circumstances of the case, the justifications may or may not be sufficiently meritorious to justify a change in position. And that's precisely the sort of existing test and one which we say should not be tampered with. And we give the example, I probably don't need to labour it, in paragraph 54 of our skeleton of what we say is the closely analogous situation of a party withdrawing a prior admission. I don't take you to it, but it's there, paragraph 54. We say that the discretion is sufficiently wide, it doesn't need this further restriction. So those are all reasons why we say the appeal should be dismissed. We also have, as the court's aware, grounds set out in our respondents' notice, many of which I've in a sense flagged as I've been going along because it makes more sense to do so. Can I just quickly though say something about them and whilst
Yes.
also trying to give my learned friend an opportunity to respond. There are 3, I think, additional points we rely on our respondents' notice. No, 4, sorry. And the one that
You've got a document at page 149 saying draft for section 6 respondents notice.
yes, I have no-
That is the
that
real
is it.
thing. is
Yes,
it?
I have no idea.
That's fine.
Well, I apologise for that. I think
So long as it's the right document.
yes.
Right, respondents notice.
It is. We deal with it in our skeleton. I was going to deal with it by reference to our skeleton. 'Cause I think
Yes.
the arguments are developed in our skeleton at paragraphs 57 through to 79. And the one I'd like to develop first is the last, which is the point picked up at paragraph 70 of our skeleton argument. And that is the question of whether this was something that actually was relied on by Judge Cadney for the purposes of his decision. And I've already taken the court to, oh, sorry, no, I haven't. Can we go, if we go back to Judge Bird's judgment and pick that up at paragraph 49, so that's in the core at page 50. At paragraph 49, Judge Bird said this: the appropriate, where he's talking, it's perhaps better to pick it up at 48, where he's saying that the second question answer positively requires consideration of all the material circumstances of the case, likely to be influenced by a number of factors, including the degree to which the first stance contributed to the first decision, the presence or absence of any unfair advantage gained by the asserting party, or any unfair detriment to the opposing party, and the reasons for adopting the first and latter stance. The appropriate degree of connection is expressed differently in different decisions, on the footing of, on the ground of, or because of a reason for the order, or at least where the first decision was arrived at after a balancing exercise, a material factor. This causal link, and so the second question was the second of Lord Justice Sacharowy's key questions in Malik. Bearing in mind the need to adopt a broad merits-based approach, it seems to me the closer the connection between the first stance and the first outcome, the more likely it is that the administration of justice would be brought into disrepute if the later inconsistent position is accepted. The degree of connection is likely to carry a good deal of weight if the first decision would not have been reached if the original stance had not been adopted. It is unlikely to carry very much weight if the decision would have been made in any event, and even if the stance had not been adopted. Now, applying that approach in our submission, the judge, for the reasons I've already outlined when I went through the judgment of Judge Cadney, should, in our submission, have concluded, based on what Judge Cadney actually said, should have concluded that the first decision, as in Judge Cadney's decision, would have been reached regardless of the original stance, as found by the judge, and the decision would have been made in any event. And in saying that, the judge, Judge Bird, was effectively picking up the analysis of Sir Christopher Floyd, who himself actually was picking up that of Justice Ginsburg. But it might be worth reminding ourselves that Sir Christopher Floyd had said that, and it's at 26, paragraph 26 in LA Micro Group, I'm just going to quote it to you if I may, but for your reference, it's tab 7, page 115. Absent that factor, i.e. that the earlier decision was obtained on the footing of or because of the stance, the doctrine did not apply because there will not be an impression that one or other court was misled into giving its decision. Now here, if the same outcome would have been reached on the interim application in the Employment Tribunal, the estoppel will not arise, as IVL has not obtained any unfair advantage as a result of the alleged contradiction. If one stands back and says, well, hold on a minute, let's say nothing had been said about the regulatory position of EDD. Here is this standalone ground that was being advanced by EDD for the dismissal of Mr. Lay, supported, as the judge recognised, by evidence and by documents, and on which he couldn't properly conclude on an interlocutory interim application, couldn't properly conclude that the claimant was likely to succeed in showing that those explanations were false. The judge put it very fairly, said, well, it may or may not be, but he couldn't conclude on that kind of application that Mr. Lay was likely to succeed. And if, on that basis, in my submission, one cannot properly conclude, I would submit, that that earlier decision was on the footing of or because of anything said by EDD. But it goes a bit further than that, because when one also looks, and this is why I spent time with the court looking at the nature of the alleged protected disclosures and the absence of any identification of the regulatory provisions relied on. When one looks more and more closely at how Mr. Lay was putting his application, it was very much about being blocked from making an FCA authorisation application, rather than explaining what, if anything, EDD was said to be doing in breach of a relevant regulation, which he was drawing to the attention of either EDD or his employer, not, incidentally, the FCA, which if you
normally make an application for authorisation to the FCA unless you think you need to make one. So although I take the point about the lack of detail, the whole premise that underlies the fact that he's complaining that he's not being allowed to make an application is that there is a necessity to make that application, because otherwise you're operating unlawfully.
Well, yes, but I think one has to step back. Actually, the evidence, and I haven't taken you to it, but the evidence about that was that the reason he wanted to make the application, this was the evidence before Judge Cadney, was that he wanted to remove go-cardless and bottom line from the operation, because
without them it would be unlawful.
And without them it would be unlawful. And he wanted to remove them because he wanted to make more money, because he was on an earn-out. So now we don't need to worry about whether that's agreed or not, but that was evidence of, that was IVL's case, that actually his motive for pursuing the FCA application had nothing to do with this earnest desire to be regulated, but more to do with ways in which he could improve the profitability of EDD as he saw it. And the resistance to that from IVL was because they were saying, you don't need to do that. And they didn't want to do it because they didn't want a subsidiary in their group.
You don't need to do that because you don't need to remove the intermediaries, or you don't need to do that because it doesn't matter whether you remove them or not.
For two reasons. You don't, and these were the two reasons that were being explored in some of those documents we saw. As it was understood at the time, because you have the intermediaries and because there are exemptions you can rely on. And the one which they fixed upon in March 2023 was the commercial agent exemption.
Oh, that's for the direct business, not for the indirect.
But I think the plan was to move all of the business over
into the direct model.
Yeah.
I get
anyway, the point I'm making really in the context of my respondent's notice is that Judge Bird simply accepted that the stance taken by EDD in the Employment Tribunal, he accepted that, sorry, I'm going to use his language rather than mine, he accepted the position adopted was a material factor in Judge Cadney's decision, and in my submission on a proper analysis, both of the way in which that application was put and the way in which it was disposed of, that was not a correct conclusion. And the problem which, with respect this court has, is that he hasn't explained his position at all. He's just accepted it without any detailed analysis of the sort that I endeavoured to take this court to as to what it was that Judge Cadney had to consider and how he arrived at his decision and what he said in his decision. None of that is really properly addressed. We challenge that conclusion, and for all the reasons I've, in a sense, already flagged. And sorry, will you forgive me? I don't want to repeat
Right,
points that I've already made. So
have a look through and see if there's anything
Yes.
you still need to make.
yes, I think I've made my point. I'll just be repeating myself, but you have the points I make in Judge Cadney's judgment. There are 3 other points that we have raised. One is that IVL's position was not clearly inconsistent. The second, just to tell you what they are, is the relevant contextual considerations, circumstances in which the application had to be dealt with. And the third is different questions and different time periods, because we're concerned only with the position as at the date of completion, whereas the ET is concerned with subsequent operation of the company. Those, I'm conscious that I need to give my learned friend an opportunity to respond. Those 3 are all dealt with in my skeleton. I'm actually very happy to carry on and address you on each of them, but it may be that the court has heard enough from me anyway.
Time marches on. I'll see it. To my
Do you
colleagues.
feel that you've sufficiently covered them in your skeleton argument, Mr. Totsley? Because I don't want you to feel at a disadvantage.
No, I appreciate that indication. I mean, like any point that's covered in a skeleton argument, it can always be improved upon by just taking the court to documents and so on. But on the basis that the court will actually look at the underlying documents that we've identified and so on, then I would think they are sufficiently covered.
I mean, the point about the period is self-evident.
The point of that's a 2-liner. Yes, that was my shortest point by a long way. Perhaps I can just take you very quickly through something, because I don't want it to be thought that I've somehow abandoned these points.
No.
I absolutely haven't. If we took the relevant contextual considerations, there are 7 points we identify, and I'll take them quickly. The first is the focus of the regulatory issue before Judge Cadney, which is very different to our focus. The second is that Mr. Lay didn't make any submissions as to the basis on which he said EDD was carrying out regulated payments.
Well, you've made that point already.
Yes, exactly. The third is that the appellants accepted before Judge Bird that the ET was not misled. I've given you the reference to that. The fourth is that the appellant, sorry, I'm not understanding my note to myself. Yes, the fourth is the warranty. The appellants warranted that the EDD was compliant with all laws, and one starts off in my submission with the proposition that you would expect as a buyer those warranties to be true, and you would assume them to be true unless you've got some hard evidence to come to the opposite conclusion.
That's why you wouldn't normally serve a breach of warranty notice without knowing what the situation was.
Well, unless you needed to preserve your position,
Well,
and that's the trouble with the
whether
2
that's
years.
justifiable or not is another matter, but that's for another day.
Yes. Well, and if I may respectfully say so, I agree. Yeah. No, I'm going to repeat points I've already made. They're just put in a slightly different context, and they're in the skeleton. And on, well, whether they're inconsistent, I'm not going to address you on that. I will rely on my skeleton, which means, in a rather undramatic and pathetic way, I've come to the end of my submissions, unless I can assist the court there.
Thank you very much. Mr. Hank? Mr. Bale?
Mr. Totsi opened his response by taking a point that doesn't, as I think he very fairly accepted, emerge in any way from Judge Bird's treatment of the application before him, which is the suggestion that everything can be rediscussed and relitigated at the trial in November. That's to say, everything pertaining to the question of approbation and reprobation. The judge's view, we can see from the judgment, which is that he thought he was deciding the question, not just on an interim basis, but reaching decisions as to the elements of whether or not there was what the US Supreme Court would call a judicial estoppel. So if we could go to tab 5 of the main bundle.
Judge Bird.
So sorry.
You're talking about Judge Bird, not in a sense, of course, it's not an interim decision. If he'd acceded to the application to strike out, well, that's that, isn't it?
Yes, he decided it the other way. He didn't say, I find that the defendant IVL has an arguable case that it is not abusing the process. I want to show you what he says at page 52 of the bundle.
Right.
Try and make that good. What he did was first of all to reach a positive finding at paragraph 61 that clearly inconsistent approaches were adopted as between the EC proceedings and these High Court proceedings. So that's a finding, and he reaches that as a conclusion. And going forward, there would be subject, obviously, to the any outcome here, but prima facie that would create an issue of estoppel. And the second finding, so that's a finding of fact, of course, and the second finding of fact is the one that's summed up at the end of 64. That the position adopted by EDD and IVA before the Employment Tribunal was a material factor in that decision.
Is that a pure finding of fact or a mixed finding of fact and law?
I'd suggest that the question whether a particular position taken by a party has caused has been a material factor in a judicial decision is a question of causation, and I would suggest it is a question of fact. Alternatively, it is at the least mixed fact and law. But once one identifies the test as being, is it a material factor, that's the question of law, and then the application of that question of law is a question of fact. So that's another finding reached by Judge Bird. Leave aside just for a moment its characterisation. And I would suggest that the question for this court is whether, having reached those conclusions, subject to respondent's notice, but if one just takes those conclusions as a starting point, was Judge Bird justified in his reasons for not finding an abusive process, which are what he states at paragraphs 65, 66 and 67. So if to take the simplest objection we put forward to his approach, legal advice is, broadly speaking, irrelevant in principle. If that proposition is correct, CF Lord Justice Sales in the Gerber case, then a trial of any issue relating to the question of approbation, reprobation, stroke abusive process would be completely inapposite, because the only factor which means that the findings the judge has previously reached, namely there was a clearly inconsistent position and it was a material factor in a previous judicial decision, the only factor which means that those two findings don't lead to an abuse would be a factor which was irrelevant in principle. Now, a further reason why the concept of having a trial on this issue is a chimera, in my respectful submission, is that there wouldn't, in fact, be the further material that one would actually need to investigate it, because the difficulty, apart from the question of principle I've just identified, of can you look at somebody's legal advice in principle, is that Judge Bird didn't have the legal advice because it's all been withheld. And there's no suggestion from Mr. Totsi, let alone one backed up by some sort of evidence, and if there were, it would have further objections, but there is no suggestion from the respondent's side to view that when it comes to trial, they will reverse the position that they have steadfastly maintained up until now, which is that they're not waiving privilege, they, IVL, are not waiving privilege over any of the advice that they obtained.
You say the sum total of the evidence in relation to such legal advice as was available to EDD/IVL is what we've seen and what Judge Bird saw, which is the information in the slideshow from Pinson's and the various pieces of advice given by Mr. Finney at various stages.
Yes, various. So what one, and it's an inapt phrase I use it only for convenience, the sort of indirectly transmitted advice, which my ladyship has pointed out. But what we don't know, and what IVL have been very clear about asserting, is what advice they received, and as I said to you before the short adjournment, what view of the matter they then took, having received that legal advice. So, for example, in the supplemental bundle at page 255 and tab 27, the statement of Mr. Murdoch, the DNA Piper solicitor, he says at the top of that page that he's not waiving privilege, you can see paragraph 3, on any advice that wasn't shared with and seen by Mr. Lay at the time. And then one can see in Mr. Phillips' witness statement for this application at tab 28, page 272. You have only extracts of that statement, as you heard. That and I just ask you to note, but won't read it out, the two preceding paragraphs, 25 and 26, which talk about how they brought in DNA Piper. And then 27, he asked DNA Piper to check if Mr. Lay was right about the need for an FCA licence. He then says they had limited visibility. Shortly after DNA Piper discussed all of the regulatory points with Fox Williams, and that discussion was known. In this witness statement, I refer only to DNA Piper advice which was discussed between IVL and EDD at the time, etc. And he goes on to say he's not intending to waive privilege. So it's obvious that there was something else in which they don't wish to waive privilege, and they say we're not waiving privilege in it. And that is the critical material which would be needed to conduct any sort of further assessment, but which this party IVL has very clearly chosen not to put forward. And to come along now and say, oh, well, we can have, on issues which we've lost, we want to have a rerun, namely, was there a clear inconsistency and was our posterior material factor in the ET decision? We want to rerun that. But also we want to be able to have the prospect of a trial where we've chosen to withhold the key material and without any indication that they would somehow release it. So I do suggest that this prospect of there being a trial is not a fair, realistic or proper one, which no doubt explains why Judge Bird, in my respectful submission, did not express himself in the sense that I'm leaving things open to be determined later. I'm just deciding that there's an arguable case that IVL could run this inconsistent position. And if I may say so, if one looks at the end of Mr. Totzi's skeleton argument for this appeal, in the main bundle at tab 12, page 173, their conclusion, second sentence of paragraph 80, it said, it is not an abuse of process. In other words, it is not an abuse of process. Well, it may not be, but it is not an abuse of process for IVL to contend as part of its counterclaim that EDD's operations as at completion included carrying on regulated payment services outside any applicable exemption. In 81, they don't obtain, third sentence, they don't obtain any unfair benefit by advancing its counterclaim in these proceedings. Not, this is something that will have to be fought out later, but that is the result. So there's been a shift of position from that in oral argument. Judge Bird, just reverting to what he said at page 52, in paragraph 67, says in the fourth line, towards the end of the line, the lawfulness of EDD's pre-completion business model is key to the outcome of the present claim. In my judgment, so that's the substantive underlying issue. In my judgment, the administration of justice is best served by determining that issue in the light of the facts as found by the trial judge and applying the laws it's found to be. So that issue, the lawfulness of the pre-completion operations, is what Judge Bird decided should be determined at the trial, not that issue, but before we get there or alongside it, an issue whether or not that issue can itself be litigated. Simply wasn't his decision. And so what you're being invited to do is more than just reconstructive surgery, it's a personality change for Judge Bird's decision.
Just to unpack this for a minute to make sure I understand it, were you to succeed on this appeal, you would say that issue would fall away?
Yes, the underlying lawfulness.
The question of the lawfulness of that would no longer be an issue.
Yes, that would be the preclusion.
Yes,
absolutely.
Yeah.
Yes, quite. And we say that because the pivot to the fulcrum of Judge Bird's decision, his ruling, not to grant the application whereby the defendant would be precluded,
it's open to the defendant to run it.
Yes, he
He's
says
ruled it's open to the defendant to run it. So you're not pushing that can down the road for the trial judge.
no.
At all.
No, not at all. You're saying, I'm deciding that now. That's what he said. And the reason, the fulcrum of that decision was Judge Bird's view that there'd been a change in legal advice, this unidentified advice with unidentified facts. And in the interest of time, I'm going to press on so that I can address as best I can the other points made by Mr. Totzi. So in response, headline points in response to what he said to you this morning, the start of this afternoon, forgive me, that nothing in what you've seen addresses or illuminates any advice given to IVL, number one. Number two, there is no identification of any specific fact which was not known or which was mistakenly apprehended by IVL. The most that Mr. Totzi was able to do was to take you to a wholly high-level generalisation by Mr. Phillips, the IVC executive, who says that Mr. Lay didn't give us details of how EDD was operated. But we're dealing here with EDD's basic product which it sells, makes available to thousands of vets around the country, which is a dashboard plus an arrangement for a payment service. And so it would be necessary and appropriate for a party saying that I had some misunderstanding about the facts to identify against that perfectly simple factual background, basic factual background, what the fact was that it said it didn't know and why it didn't know it. But you haven't got any of that, and Judge Bird didn't have any of that, and Judge Bird didn't purport in his judgment to identify any such fact. The most you have is these very high-level generalizations, which could mean absolutely anything. It could refer to Mr. Lay's personnel management. It could refer to how he wanted the accounts to be put together.
What I would have expected to be said if it were the case
I'm
would
sorry.
be, what I would have expected to be said if it were the case is, we had no idea how the indirect model operated. We did not know that it operated by means of using these two big payment companies to pay the money by direct debit or whatever. I mean, they might have said, well, we didn't know the finer detail of it, but the idea that they didn't know the actual basic skeleton of it seems a little strange.
Well,
Especially if they're buying it as a business. I mean, the first thing you do is try and find out what the business is that you're buying.
it is for the party that is putting forward the suggestion that there was a change in legal advice which justified its change of position, and that there had been a change in its knowledge of the facts, or the facts had been withheld from it, to identify what the change was. And that involves saying with some degree of specificity what you believed at point X in time, and then what you later believed at point Y in time, and showing how that matched onto the position you took in different parts of litigation. But Judge Bird didn't make any such findings, and he, as I attempted to show you this morning, he simply didn't have the material that would have allowed him to make any such findings. So that, we say, is itself on its own fatal to the construct which Judge Bird invoked in order to validate the change of position, notwithstanding that there was a clear inconsistency and that he found that it was a material factor. So put another way, there is nothing that displaces the obvious conclusion that on any view, IVL appreciated that there was the potential for argument about the lawfulness of pre-completion operations. And the evidence that it had put forward about the indirect advice transmitted to it, EDD's advice that it had shared by Mr. Lay, that Mr. Lay had chosen to share with it, that of itself indicated that at least at times there had been some scope for argument, or the belief that there might have been some scope for argument, and not last but not least, there was a breach of warranty notice which asserts, with whatever caveats, asserts as a fact that there was illegality in the pre-completion operations of EDD. So there is simply nothing to displace the conclusion that IVL made an election with knowledge of the potential for different legal arguments to be made, different postures to be taken about the position of this business. Nothing has been shown, therefore, to undermine the choice that was made. For example, one might in principle say, as in other areas of the law, my choice, e.g. to enter into a contract, can be undermined, vitiated by a fundamental mistake of fact. There are all sorts of possibilities that the law recognises as undermining the choice, but you have to show what it is, the specifics of what it is. And we say, not only do they fail on the facts, IVL, to show such a cause, but as a matter of principle, just as Justice Ginsburg did when she rejected New Hampshire's attempt to change its case, you would have to show, following ordinary principles, you would have to show that there had been the discovery of something which was not reasonably ascertainable at the time when you first took your
That's the point, isn't it? I mean, if you look at the American case, the whole thrust of the argument that Justice Ginsburg rejected was we didn't know then what we now know. And her response to that was basically, well, you should have found out.
Yes, you
Well,
should.
you had
should
the
and could.
opportunity to find out and you could have looked. I suppose what the other side would say in this case is, well, we did try to find out, but Mr. Lay was withholding the information.
Yes, but then they would have to do more than simply have to do two things. They'd have to do more than simply utter a generalisation that Mr. Lay kept things very tight to himself. They would have to identify what it was that they now know that they didn't know before and how that bore on the position. And they'd also have to say, this is the legal advice that we got as a result, which caused us to change the position. And they don't do either of those things. My lord and my ladies, I'm going to press on, if I may.
How much further are you going to press on?
Well,
Mr. Bayard?
would your lordship be willing to give me till 1:30, or is that?
Yes.
Thank you.
That's a
Appreciate
deal.
So a point was raised which doesn't, with respect, feature, and I do take this, in the respondent's notice at all, which was that the application for interim relief was an application against EDD, because obviously only EDD can comply with any order that's made, so only EDD is the employer. Now, that's not a point taken in the respondent's notice. An obvious answer would be that, in fact, rightly or wrongly, IVL was joined as a respondent, and it was therefore a party to the Employment Tribunal proceedings. It's listed as a party, and it's referred to by Employment Judge Cabinet as one of the plural respondents. So that's the first point. The second point is that an obvious answer to any concerns about that would be that IVL was in privity with EDD. If one looks at Ms. French's statement, I just want to take you to that quickly at page 120, tab 16 of the supplemental bundle. You will see she says at the bottom of paragraph 8, and she is a witness from IVL, which is the Greek counsel. The second respondent had bought a business which was not required to be regulated. The second respondent understands that there is no legal regulatory imperative for the first respondent to become regulated. It can rely on the support. So assertions are being absolutely plainly being put forward on behalf of, in the name of, and representing the mindset of the second respondent, IVL, and similar statements made in paragraph 5, which I won't read out in the interest of time. So it was next said, well, how can you say that there's been disclosure, a public interest disclosure to the, in this case, where the disclosures were all to the purchasers? Now, the short point on that is that aligns
I don't think Mr. Totsi didn't put.
I'm so sorry.
Put that as a point of order. I was just asking as a point of information, and Mr. Totsi confirmed. It doesn't stop it being a protected disclosure within the Act.
Very well, Mark. The point I wanted to make was that there is a broader failure in the respondent submissions to separate out two things. The claimant made his complaint about alleged protected disclosures. There was then, in response to that, a broad approach taken by the respondents, which was to say, across the piece, there is no difficulty with the lawfulness of the operations of EDD, and that includes the direct model and the indirect model. So everything about this business is lawful, but moreover, we can simply continue to operate the business as it was operated before, and Miss French in paragraph 8 actually says that. And that, of course, is why Judge Bird, perhaps not in the happiest formulation, but says that, in effect, the respondents were saying that they could drop the direct model. That's just a paraphrase of saying we could continue to operate as we were before, which is the indirect model, and that is ultimately an accurate basis of what we said before. Can I just quickly deal with the question of causation? If you go to the employment judge's reasons, which are at tab 21, sorry, I made my submission this morning that even if you have two completely separate grounds of decision, it's enough if one of those grounds of decision has had a material factor from the previously inconsistent stance. And you can't get around the doctrine by saying, oh, well, the overall outcome would have been no different because there was another completely separate ground, even if that is the case. On that first ground, just so that one can see page 182, paragraph 28, on the information before me, fourth, third line, says Judge Cadney, there are live issues of fact and law. When he says that, he's referring back to paragraph 23, first sentence, the respondents submit there are factual disputes underpinning the claimant's assertions. And he then, at the bottom of the page and over the page, says that the claimant was entirely accurate in saying the existing operating model was in accordance. And then again, in the last sentence, Judge Cadney says, there is therefore a live issue. He uses the same phrase as to whether the claimant will be able to demonstrate any public interest disclosure. So I submit when one looks at the language that he's used, it's perfectly plain that there is a causative impact. The final point that I'm going to address in the last minute is that the impact of claiming privilege. There is a confusion with respect in what Mr. Totsi says. Of course, it's right, following Wentworth and Lloyd, that you can't draw an adverse inference against somebody for claiming legal professional privilege. But it doesn't follow, as Lord Justice Hughes points out in the Edward Stubb decision that we added to the bundle, paragraph 10, doesn't follow that that means that the party claiming privilege can somehow use that claim to fill a gap which he needs to fill in order to make good a particular case. And as Lord Justice Hughes says, sometimes in order to make a case, there is a, quote, practical necessity, unquote, to waive privilege. And if you don't, then you simply don't have the building blocks for that case. It's not a case of an inference being drawn against you. It's just that you haven't got the material, and that's your choice. And that, with respect, is the situation that we are in here. It would be wrong to speculate as to what the advice was that IVL have been so careful to keep from view. They're allowed to keep it from view, but having done so, the building blocks for the justification that Judge Bird found are simply absent, and that is why, among other reasons, Judge Bird was incorrect in the decision reached, and why we invite my lord and my ladies to reach the opposite decision.
Thank you very much. Thank you, Mr. Bale. Thank you all for your submissions, including those whose contributions written rather than oral. We'll reserve judgment. We will do our best to give a judgment with reasons this month, but we appreciate if we can't do that, at least you need the result this month so that you know on what basis to prepare for November. We're not in a position to give undertakings, so we don't do that, but we appreciate constraints that you're under and we'll do our best. You know the other two things I have to say in every case. We will send out, when we do send judgment with reasons, it's sent out in draft. That doesn't mean it's being sent out to be re-argued, just for correction of typos, errors of dates and names and so forth, not for re-argument. And the contents of the decision are confidential to the parties and their legal advisors until formal hand down by promulgation on the National Archive website. Thank you all very much for your assistance.
Court rises.